I'm honored to be here and honored to address my future profession. The only other thing I'll add, you may have heard in the little back and forth, my undergraduate degree is from Morehouse, so I'm particularly heartened to be here at an HBCU pre-law summit. I'll also add, as a preliminary matter, that I'm on Harvard's admission committee, Harvard Law School's admission committee. So those of you with, really good grades and really sharp and aggressive and go-getter and persistent, one of those rules, find me before I leave. I do have to get back to Boston today. But find me and we'll stay in touch because we look through a number of applications every year, and I always take a special look at the HBCU applications. I want to talk a little bit to you today about justice. Ms. Chapman, I don't know if she's still here, in her opening remarks, there she is back there. I was moved as well by find your why. Find your why. Most people go to law school because of some sense of justice. And whatever area you go into as a lawyer, even if you're a mergers and acquisitions lawyer, there is space. There is space for you to make sure that some justice gets done in this world. One of my mentors is John Payton. He's passed away now. Great friend, was a big firm lawyer his whole life. Did more pro bono work than anybody I think I ever met. You guys know John. Great guy. So no matter what you want to go into, there's always space for justice. I want to tell you a quick story about three people. Here's how I've sort of done my work in terms of justice work. So I've tried to somehow intersect scholarship with the real world. Scholarship, theory, and practice. Find that point of intersection and do what I can do to sort of help make this place a little bit better. And these are the things that all of you can do, right? These are things that all of you can do with your legal career too. Maybe not precisely the sorts of things that I do, but there is space for you to do some of these things. So I started an intellectual project a few years back where I looked at every wrongful conviction in the country, right? I mean, that's what scholars do. We find something and just, we're going to do it, right? Just look at everyone in the country. So I looked at every wrongful conviction in the country, right? And the majority of those were people of color. You may not be surprised by that. And what I did is wanted to see if there are some commonalities. If there's some commonalities between all these wrongful convictions, right? And one thing jumped out when I looked at all the exonerations across the country, DNA exonerations across the country. What do people think the number one cause of a false conviction was? Somebody said it. What'd you say? Eyewitness. More specifically, single witness identification. Single witness identification. That somebody got on the witness stand and said, yes, it was you. I saw that person with my own eyes. And I had done some work a few years earlier with a colleague over at the Harvard Medical School, and we understand why, right? Because people think that their memories are like tape recorders or video recorders, and they're not. Memory, it turns out, is highly contingent, right? So if I ask you guys to think about what you were doing, last night at 8 o'clock, right? And you're standing, I put the time up early. Now, so, 6 o'clock, all right? You're here? All right, so think about what you were doing at 6 o'clock yesterday. And most of you can instantly tell me what you were wearing, right? How you looked, what your hand gestures were. right? When you think about it, I'm talking to somebody, tomorrow I'll be able to talk about myself doing this. But the thing is, I can't see me. I can't see me. But tomorrow I'll be able to tell you what I was wearing, what I was doing, how I was standing, right? Memory is contingent on a lot of things, right? So single witness identification. And even worse is cross-racial identification, right? And this is the project I did with my colleague at the medical school. It's called perceptive narrowing. The notion is if you're not around people of a different race or ethnicity between the ages of 0 to 6, you have a very difficult time making nuanced determinations of difference. I grew up in Gary, Indiana, right? So I knew it firsthand. I grew up in Gary, Indiana, and then went to an HBCU. The very first time I sat in the classroom with a non-black person was the Harvard Law School, right? And I had the darndest time telling my classmates apart, right? So when I grew up, my mother used to say, people say all black people look the same, and that's racist, right? And I got to Harvard Law School, and somebody said, oh, it's the, so-and-so with the dirty blonde hair and the green eyes. And I thought to myself, one, I didn't know what dirty blonde hair meant even. What are they talking about? And how in the world am I supposed to know what color eyes somebody have? That might sound silly to you guys, but I've just never been in that space before, right? And it's called perceptive narrowing. I grew up my whole life describing people in terms of maybe skin color, hair length. Those are the sort of things my subconscious looks for. And that's how it works with perceptive narrowing. So anyway, just horrible. So I looked at all those DNA cases, pulled out the 3 or 4 big things that stuck out, right? And then I said, DNA cases represent only a small fraction of the convictions in the country. So I wanted to look at the non-DNA cases. The thesis, for any people with science backgrounds back there, is, right, if these things hold in DNA cases, you're going to find them in non-DNA cases. And that's going to then allow you to triage, figure out what cases should we be looking at in the non-DNA side. Fast forward to about 2014, Brooklyn DA called and said, can you design this system to look at old convictions in Brooklyn, New York? On behalf of the prosecutor. He had heard about the work I was doing, and I said, yes. We went in there, designed a system. As of today, as I'm standing here, we have vacated over 20 convictions. These are black men who have been in jail for years and years and years. I want to tell you about 3 people very quickly. First one is Roger Logan. Roger Logan wrote me a letter, handwritten. Professor Sullivan, I've been in jail for 17 years. I was framed. Can you look into my conviction? That's all I had, right? I looked at it. Guess what? Single witness ID case. So I said, okay, that doesn't mean all of them are bad. That means that you got to look at them. You got to look at them. So we took a look at it. Here are the facts, very quickly. Witness says, the night before I saw Mr. Logan in an argument about a dice game with some people, a heated argument, nasty argument, all kind of bad words flying back and forth. Then, that next night, I saw him walk down the street right in front of my house. I live right next door to where this thing happened. He opens up the vestibule to a building and opens fire, shoots 10 times, killing one person, injuring others, right? Seems pretty open and shut, right? Got a witness, they go to trial, he loses, sits in jail 17 years, we look at the case. First thing I do, at this point, the DA had hired me as a consultant, so I had set up the program, so I send one of the attorneys down there, one of the prosecutors down there, and a detective to look at the scene, right? First thing we notice is that she did live right next door, this witness, to where it happened, but not right next door. Now, her testimony was that she was outside and heard the first shot, bam, everybody starts to run. She runs into her house, looks out the window, still shooting. The forensics say there were 10 shots. It makes sense. This guy's convicted. But she was in the next building, but it wasn't right next door. So what they did is stood outside, and the detective raised his hand, pretend gun, shot 10 times. Pow, 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 while the lawyer runs over to the building. Bottom line is, Usain Bolt couldn't have made that trip in 10 shots, right? Let alone this witness. So now we're suspicious. We're like, all right, so what's going on? So we start digging and digging and digging. It turns out, so remember I told you, witness says, I saw them arguing the night before the murder. That's how I know it was him. They're arguing about a dice game. Turns out that witness was in the custody of the New York Police Department the night before. She had been arrested and was in jail, not let out until the evening of the murder. And she couldn't have made it back to Brooklyn from the precinct at the time of the shooting. It was an out and out lie. Out and out lie. So we stood in court, and this was about our fourth or fifth vacator, fancy lawyer word for get out of jail. This is the first one I went to, right? So I said, I'm going to go. I'm actually going to do this one. This one had really gotten to me, handwritten letter and all. So for the lawyers here, what judges do all the time when everybody can leave, the judge will say, Mr. So-and-so, you're free to go. And it's just, if you ever get a traffic ticket or something, you're standing in court, if you take it to court, judge, you're finished, judge says you're free to go. We went in there, moved to vacate the conviction. The judge granted it. This man had been in jail 17 years. He looked over there and said, Mr. Logan, you are free to go. Oh, my God. Mr. Logan broke down. His family broke down. And I broke down. Now, lawyers, you're supposed to be stoically objective, right? It was a massive feeling. That African-American man had been in jail 17 years for a crime he did not commit, right? That's what your law degree can do. That's what your law degree can do. Second one, guy named David McCullough, arrested at 15, had been in jail 29 years. 29 years. Looked at his case, my team and I, for over a year. Again, this is a 30-year-old case. We're digging up old records and so forth. Turns out he and his co-defendants were force-fed a confession. So it's one of the other things that you look at, juvenile confessions without parents involved. Risky. Maybe true, but risky. So we look deeper and deeper, and it's something in the scholarship called a force-fed fact, meaning if a person confesses to something that she or he could not know about at all, then someone fed them that, right? And there was evidence of a force-fed fact, all kinds of stuff. I don't think I have time to get into it. But here's the part about David's case. He had a co-defendant, another guy. His last name was Stuckey. He was in prison with him. We moved to vacate both convictions. This is 29 years later. Mr. Stuckey died in prison. His mother sat at counsel table sobbing, saying, I knew my baby didn't do this. I knew my baby didn't do this. And the district attorney in Brooklyn, Ken Thompson, he didn't have to do this, but he vacated that conviction posthumously, meaning after death. It's something he didn't have to do, but vacated that after death. The third one, just to give an example, I'm going to wrap this up, is a guy named Fleming, last name Fleming, right? In jail 20-some odd years, maintained that he was in Florida at the time of the murder, right? Maintained he was in Florida at the time of the murder. Again, single witness ID. Took a look at the file. This was the easiest one yet. In the district attorney's file and in the police file, there was a receipt. There was a receipt, a telephone receipt from Walt Disney World. It was in his pocket the day they arrested him. And they never turned it over to the defense. He was in jail 2 decades. Two decades. So now the other thing I did with this work is after we've uncovered some of these are all non-DNA cases, right? After we uncovered some of the causes for the mistakes, I started training prosecutors, right? And I would use that Fleming case. And I would hold up as a receipt like this big, small little receipt. And I would hold it up and say, you don't want this to be you. All you have to do is look in the file. You don't want to be responsible for another human being in jail for decades because you didn't look in the file. This is an easy one. So it goes to show you the sense of how communities in power think about people who look like us, right? 20 years here, 20 years there. But you as future lawyers can do something about this sort of thing or other things, right? Here's my point. How am I on time? 3 to 5 minutes. Here's my point. Justice is not some airy process. So who's my political scientist here, right? Plato thinks of concepts like justice as something that exists in some sort of realm that's inaccessible. You die and bump into a triangle or something somewhere out in the atmosphere somewhere. I think Plato misses the mark. And I think that we have to understand concepts like justice pragmatically. Right? That means justice is something that we do. We have to do justice. Justice doesn't happen. You walk around, oh, here comes justice. Nah. Justice is something that we do. We make happen. We roll up our sleeves and make justice happen. And that's the power of a law degree. The law regulates every aspect of our lives. Every single aspect of our lives. Martin Luther King said time is a neutral concept. You can use it constructively or you can use it destructively. If you want to make justice happen, then you have to use time constructively and actually make justice happen. Allegra said something something else that really touched the nerve here. And this is this notion of what each of you can do. I remember there sitting in these seats as a young guy from Gary, Indiana, not exposed to nothing at all, right? Thinking, hearing people and saying, how in the world could I do something like this, right? I don't know about you. I didn't even know about Harvard and Yale. I mean, I kind of knew about it, but you never thought I'd have a life appointment at Harvard. Hey, I'm from Gary Roosevelt, right? It's what I'm thinking. So here's something. I want you guys to get this, but I thought of it when you were speaking. But Ralph Waldo Emerson gave a famous speech. It's a Phi Beta Kappa speech in the late 1800s at Harvard University. And what he did was talked about great people. And he used great people as what he calls exemplars. Exemplars. He looked at the qualities of great people. And what he told those Harvard students back in the late 1800s was that great people sort of shouldn't be scary, shouldn't be a barrier, but we should use the best of all these examples that you see to figure out how you can do it. His point was that great people exist so that even greater people may exist. Right? And I'm confident that there are several of you, when you say, I forgot the example, the 12-year-old or 13-year-old boy or girl, right? You are going to be that person very soon, because life happens quickly. You're going to be that person that folk are looking up to, right? And you can use it constructively or use it destructively. But take from all of these examples, and what Allegra does, what I do, what your next speaker does, right? And just remember Emerson, right? Great people exist, and this is not an arrogant thing. I'm far from great or anything. Great people exist so that even greater people may exist. So fill in the blank of whoever your heroes or sheroes are, right? Use those qualities and just go out and do it. Just do it. Because again, justice it doesn't happen. You have to actually do justice. I'm so proud of each and every one of you. Email me if you're ever in Cambridge. Come see me. If you want to go to the Harvard Law School, definitely email me. And my email, rsullivan at law.harvard.edu. And I'll give you what I tell my students, and it's the 24-hour rule. The 24-hour rule is that if you don't hear from me in 24 hours, that means just to write me again, because one of them, I feel incredibly blessed in so many ways, but one of the downsides of being a public intellectual is that I get hundreds and hundreds and hundreds of unsolicited emails a day. These are solicited emails, but sometimes they fall through the crack. So it's not bugging me. If you don't hear from me, that doesn't mean I don't want to talk. It literally means I just haven't seen it, because it gets, my staff puts them in 5 or 6 different folders, and sometimes I miss it. Don't hear from me in 24 hours, email me again. 24 more hours ago, you don't hear from me, email me again. And I'm begging you to do that. I do want to talk to each of you. Sometimes I do miss them. I got a couple questions, and I've got to turn it over. R. Sullivan, Sullivan, at law.harvard.edu. No, maybe somebody from Harvard is here, but no, not me. Well, no, different states have different rules. So now the civil aspects are going. The first guy, the guy from Florida, I think that settled for about $6 million city and state. So they do sue the states. Some states have liability caps. I don't know what for example, Georgia is, but some don't. I found that most of it was sort of laziness. Didn't find examples of affirmative malice. I'm getting you guys are too young to know the Apollo hook. I didn't find most of it to be malice, affirmative malice. I found it to be just, processing, like these black bodies were little widgets going through a conveyor belt or something like that. There are some cases around the country of affirmative malice, to be sure. But a lot of these New York cases were really, really sloppiness. I'm going to hang around as long as I can, too. Thank you all very, very much.